Defendant and all counsel. The court has received a motion for mistrial for the sentencing phase and an objection to the motion for mistrial sentencing phase. Mr. Nurmi, you wanted these motions heard in open court. Do you have additional argument?
I do, Your Honor. I think the backdrop to this motion really begins with two motions that were decided before this trial began on January 2nd. The motion to Ms. Arias' objection to the media coverage to having live camera feed of this trial, as well as her motion to sequester the jury. Both those were denied in the face of case law designed to protect Ms. Arias' rights to a fair trial. We think because those were denied when this trial began on January 2nd of this year, what proceeded from that day on was not a fair trial, was not a trial that comported with the constitutional dictates because of those very reasons. Now, a lot of the reasons of what happened and some of the motions made and the corollaries to those earlier motions were done under seal, so I don't need to revisit those. However, this court had a duty to protect Ms. Arias' right to a fair trial and failed to do so time and time again. Once this trial started, the prosecutor, in violation of State v. Smith, disrespected defense counsel in front of the jury. In violation of In Re Zawada, the state attacked expert witnesses in front of the jury with non-evidence designed to mislead the jury regarding the experts, attacking the messenger, not the message. Ms. Arias asked for mistrial at several points in time to do these clear violations, and this court ignored it. In between all these things that were going on, all in violation of Ms. Arias' rights, we have the issue of witness intimidation. Witness intimidation began almost the very day that Ms. Arias started a case, or at least those days when Ms. Arias wasn't on the stand. Ms. Arias made her record in that regard, and nothing was done. Now we're in a position where the intimidation continues. I have filed some exhibits. I asked, contemporaneous with this motion, I asked that they be filed under seal regarding the intimidation of Ms. Womack. The intimidation of Ms. LaViolette has been documented under seal. Now we're in a situation, Judge, where a key mitigation witness, someone who knew Ms. Arias long before Mr. Alexander came along and came into her life, has been intimidated, and you can see from the letter, who feels that her life is being threatened to a point where she cannot come forward and testify on Ms. Arias' behalf. This is constitutionally unacceptable under Lockett and Eddings and the case law that we've laid before it. As I said in the motion, this court now, this is far from a trial that comports with constitutional realities. This cannot be a modern day version of days gone by of stoning or of witch trials. This court has a duty to Ms. Arias, convicted of first-degree murder or not, to make sure that the mitigation phase, the sentencing phase, comports with these dictates. And there's pretty clear case law that this is unequivocal. In response, the state argues facts that aren't quite correct regarding Ms. Womack and her answers to the questions, her choice not to answer certain questions, which she has a right to do, by the way. But that is irrespective of Eddings and that line of case law related to her, Ms. Arias' right to present a full mitigation case, to give the jury a full picture of her life. The intimidation of Ms. Womack and Ms. LaViolette to some degree, as we've made ex parte, is evidence that this picture is not complete. A partial picture is not good enough for this jury. It just isn't. And this court then, because of this, and the state decided no case law to support their position that a mistrial shouldn't be granted, and that's because there is none. Because there is, in the face of the state's position, or in the face of any contrarian position, is well-established precedent in case law. That Ms. Arias has the right to present this full picture. She's being precluded from doing so, and therefore a mistrial at this stage of the proceedings is the only lawful remedy.
Mr. Martinez.
The issue before the court today involves Patricia Womack. It doesn't involve the court's hearings previously, and I know the counsel at every turn has attempted to chastise anyone who is near the defendant or somehow feels is to blame. He now chastises the court, and as part of that, he also chastises the prosecutor. The state believes that those comments are not well taken. The issue here is why Ms. Womack is not here to testify. As the court has been informed, on May 15th of 2013, I conducted an interview with Ms. Womack. On 2 separate occasions, she failed to answer my questions. Specifically, the first occasion occurred when I started to talk about her drug use as it involved the witness and the defendant. At that point, she deferred and chose not to answer. Rather than end the interview at that time, I chose to continue and seek whatever it was that she had to say. At one point, when she was asked about photographs of herself and the defendant, she started to equivocate. And at that point, she asked or indicated that she wanted to leave the room. She left the room in the company of Jennifer Wilmot and Kirk Nurmi, people that are not her attorneys, people who have an ethical obligation to Jodi Arias not to advise another witness such as Patricia Womack. Patricia Womack and the 2 attorneys were gone for a short period of time. When they returned, the lawyers attempted to assert her Fifth Amendment rights to remain silent. That would be Patricia Womack's rights to remain silent. I deferred on or demurred on that and asked her directly whether it was her desire, not the lawyer's desire, to assert her Fifth Amendment rights. And she indicated that it was her belief that she should assert her Fifth Amendment rights. There are many issues that are involved with this witness, and not the least of which is that she faces some prosecution, for lack of a better term, involving those photographs. We don't need to get into the detail of it because it is clear that she didn't report that income, and that would subject her to criminal penalties. Additionally, the use of illicit drugs, again, may or may not subject her to criminal penalties depending on her status in California. It is clear that she has some sort of substance abuse problem, and that's something that would have been addressed at trial while she testified. So this individual that they claim received threats came to court and that Thursday, which would have been the 16th, and at that time the court appointed Kenneth Countryman to assist her in determining whether or not she should assert her rights. At that time, Mr. Countryman indicated that he could not make an assessment and wanted to wait till Monday. It's interesting to see that the record as presented by defense counsel, or the facts as presented by defense counsel, are silent as to whether or not Ms. Womack would have heeded her attorney's advice on Monday the same way that she did on Thursday. It is the state's belief, based on that silence, that she would have asserted her Fifth Amendment rights, and that being the case, she would have been precluded from testifying. So it's easy to point fingers. It's easy to say that there is no case law that is being cited. It's easy to say that because the facts indicate that this individual, if she were to call to testify on advice of counsel, would not have testified. I do have, for the record, and I do want to make it part of the record, a copy of the interview that took place between the prosecutor and this witness on May 15th, 2013. It bears out the prosecutor's version of events, how she did, in fact, fail to respond to the first question involving drug use, and then she invoked her Fifth Amendment rights after conferring with counsel, not her counsel, Mr. Nurmi and Ms. Wilmot. She invoked her Fifth Amendment rights, and she is not here. I do not see Mr. Countryman, so I suspect that based on that silence, that she again would choose to invoke her rights, making this issue of whether or not there were any threats viable. It's an issue that can't be reached if she's not going to testify to start with anyway. So if I may mark this and have it included as part of the record.
The exhibit will be made part of the record and sealed along with exhibits 662, 663, 664, and 665.
And clearly the motion for mistrial based on the facts is not warranted, and I ask you to deny the request.
Mr. Nermi, anything else?
Yes, Your Honor, like much of what the state says, the truth doesn't associate with what it's saying. It's just simply not true. We never advised Ms. Womack to do any particular thing. She was appointed counsel. That's what she was brought here to do with Mr. Countryman. So, and the rest of the bluster that Mr. Martinez is saying to try to divert you from the reality has nothing to do with the issue the court must decide. You know, he wants to disparage her for drug use, that sort of thing. And that's exactly what we're talking about here when I brought up Smith and when I brought up Zavada. When you have a prosecutor, when this court allows a prosecutor to personally attack witnesses and counsel, that breeds an environment where this sort of thing is endorsed. And that's exactly what has happened throughout this trial with the intimidation. The other issue, and the other argument the state makes, well, she would have pled her Fifth Amendment rights anyway, therefore this doesn't matter that she got threats. Well, we don't know whether that's true or not. It's just based on the state's speculation. But let's say it were true. If she were to plead the Fifth and not be available, the picture would still be incomplete. The reasons would be different, but the effect on Ms. Arias would be the same. You see, he can cast aspersions all he wants on every witness, I guess, on his own. But he's not allowed to endorse, this court is not allowed to endorse that, and it's not allowed to endorse it, especially in the face of a system in which she is afforded certain rights at the sentencing phase. The right to present a full and complete mitigation case. That right has been ripped away from her. Thus, a mistrial, again, as I said before, is the only lawful remedy at this point.
All right, the court finds the defense has failed to establish that the sentencing phase cannot go forward and that the defendant cannot receive a fair trial in that sentencing phase. There are issues which have been raised in proceedings outside the courtroom. Those proceedings were sealed at the request of defense counsel. I am not going to review this court's decisions with regard to those sealed matters. However, this court has indicated to defense counsel that any witness they wish to call for purposes of the sentencing phase could be called in a sealed proceeding, and this court would seal those proceedings. That should address any concerns about intimidation or threats as set forth in the defendant's motion. This court can only speculate as to why Ms. Womack is not here today. Similarly, this court could only speculate as to the absence of other possible witnesses for purposes of the sentencing phase. Without more information, this court finds there is no basis to grant a mistrial, and so the motion for mistrial is denied. Mr. Nermi.
Ms. Wilmot and I would move to withdraw from the case yet again. Under Strickland v. Washington, we are in a position where we cannot provide effective assistance to counsel at this phase of the proceedings. We cannot present the complete picture that is incumbent upon us. Rule 6.8 as well, Arizona Rules of Criminal Procedure, imposes that duty upon us as well. We cannot fulfill that duty because we cannot provide the picture. There is no speculation as to why Ms. Womack is be here. She feels threatened, she feels intimidated, and she doesn't feel like she can be here. So that being said, under Strickland, Ms. Wilmot and I cannot meet that standard and then move to withdraw.
Your motion to withdraw is denied. All right. Are we ready to proceed with the jury?
Your Honor, we will not be calling witnesses in the phase given the court's ruling and the incomplete picture. We will not be calling witnesses in the defense case.
All right. I assume your client does wish to allocute.
We approach?
You may.